Okay. All right. Good afternoon, everyone, and thank you all for joining us for today's presentation, a month of service presentation of getting out of jury duty and the importance of jury service to the community. My name is Nia Murray. I'm Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Included in our partnership is also the City of Houston's Department of Neighborhoods, Houston Bar Association, Lone Star Legal Aid, the Earl Carl Institute, Harris County Appraisal District, Harris County Tax Assessors, and Houston Volunteer Lawyers. And collectively, we make up a month of service. And basically what a month of service is a month-long series of workshops relative to asset building, asset protection, community empowerment programs, and maintaining generational wealth workshops to kind of help educate and inform the community about different resources and services that are available, and what it is that they need to do to create a better quality of life, to again, maintain their generational wealth and protect whatever assets that they may have. So we want to welcome you guys today for joining us. Today's presenter is a representative from the Houston Bar Association, who's going to be giving us information about jury service in the community. What is jury service, jury duty, and why or how it actually impacts the community itself. So we will go into a little bit more detail in just a little bit. I wanted to ask everybody that if they have questions, please feel free to type your questions into the chat and we'll read them at the end, or you can raise your hand following the end of the presentation and you can ask your questions directly of the presenter if you'd like. Information that is being presented here today is for educational purposes only. If you do have questions or some legal matter in regards to jury service, jury duty, we ask that you reach out to those professionals that can assist you further with that. If you do not have their contact information, please feel free to contact Myra or myself, and we'll be sure to have your question addressed by the person that could best handle the issue for you. So with that being said, we'd like to go ahead and just remind everybody that we are streaming live on our social media platform, as well as the session is being recorded. We will be emailing a link to every one of the recorded sessions so that you can go back and review it, or feel free to share it with others that may find this information that we presented here today to be beneficial as well. So we do ask that you pay it forward and share it along. So Ms. Myra, would you like to go ahead and introduce yourself? You're on mute.
I would be on mute. Good afternoon, everyone. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods under the direction of Director Takasha Francis. On behalf of Mayor Turner and Director Takasha Francis, we want to welcome you to the month of service. It's a collaboration between some amazing partners that it's all about giving back free information to the Houston, Harris County, state of Texas community. Guys, this is all about giving you information that when you're going through whatever stressor you are going through, we've gone through hurricanes, we've gone through winter storms, we've gone through COVID-19, and everyone says, oh my God, wait a minute, what I do through whatever situation we're going through. Well, this is what it's all about. We're giving you free information so that when you're going through your stressor, you know who to contact for some assistance and some help. And guys, know you're not alone. We're walking right by your side. And guess what? We're not holding your hands. It's your responsibility to come to these free workshops and to learn and get educated in the process. Thank you, everyone. And guess what? This is a very rare moment that I was on mute. That was pretty good because usually I am talking. But thanks, guys. Have a blessed day.
All right. Again, please feel free to be as interactive as you'd like and ask whatever questions that you may have. We want this to be a conversation, you know, not to feel like you're being lectured or anything like that. So if you guys do have questions, please feel free. Jury service is something that most people try to get out of, but we're here to tell you what it is that you actually get out of serving on a duty or on a jury, and what it actually means and how it really impacts your community by serving on a jury. So we have Mr. Tim Henderson, who is going to be our presenter for today. We'll have him introduce himself and we will move right on into our presentation. So Mr. Henderson, go right ahead.
Thank you very much. My name is Tim Henderson, and I am a civil trial lawyer in Harris County and have been practicing since 1982. I do a lot of, or I did before the pandemic, but I did a fair number of jury trials. And on the civil side, I know something about jury trials and grand juries on the criminal side, and I'll try to touch on that. But in creating the presentation that I've done here today, I've done some of it myself, but a lot of it came from the Houston Bar Association that they put together over the years. And I'm just going to go through that. And then at the conclusion of the PowerPoint presentation, we can discuss and answer questions if you have any. The PowerPoint presentation basically is put into three parts. One is sort of the history of juries and why we have juries. The second part is the importance of juries, which goes to the topic described in the title. And then the third part is the actual selection process of jurors and how that works on both sides, the juror's side and the lawyer's side, and what the lawyers may be looking for. And again, my background is in civil trial law, but I'll try to touch on, to the extent that I know it, those issues that may impact jury selection in criminal cases. So with that introduction, I will share screen and start the PowerPoint. Okay, get this. Okay. This picture is the symbol of the British monarchy. And down at the lower bottom of the picture, you'll see in French, Dieu est mon droit. And you may be wondering, as I did, why is the symbol of the British monarchy, God in my right, why is it in French? And the reason for that is that until about 1350 in England, the language of the government and the court was French. And God in my right, this is the symbol that was used by Richard I. That was his battle cry and a nod to his French heritage. And the significance of this is that the way that the monarchy was in England back in this time was that there was God and there was the king, in this case, Richard I, and they made the laws. What they said goes. In fact, it wasn't even so much law as it was sort of just a dictatorship. Whatever the king decreed, that was what was done. And whatever the king said as far as who may be guilty of this or that or the other thing, that was the end of the discussion. So if the king, for example, decided that he didn't like you or your politics or the way you look, and he thought you needed to be executed, that would be the end of it. And that's how things ran in England for a long time. Till we get to 1215. And by the way, the reason that I'm going through this is because, as you may know, the jurisprudence or the science and philosophy of law that we have in the United States of America derives in large part, especially at the beginning of the country, from British law. So in 1215, you had King John and the rebel barons. King John had lost most of his lands in France in 1204 and had struggled to regain them for many years, raising extensive taxes on the barons. Translation, middle-class taxpayers. The war ended in an expensive failure in 1214. King John was already personally unpopular with many of these barons or middle-class taxpayers. many of whom owed money to the crown. In the face of his defeat in France, within a few months after his return from France, King John found that the rebel barons in the north and east of England were organizing to resist his rule. So King John met with the rebel leaders in Runnymede. You can see this is about 50 miles to the west of London. It's a water meadow on the south bank of the River Thames on June 10th, 1215. Runnymede was a traditional place for assemblies, but it was also located on neutral ground between the royal fortress of Windsor Castle, which is up here, and the rebel base, and offered both sides the security of a rendezvous where they were unlikely to find themselves at a military weakness. Here the rebels presented John with their draft of demands for reform entitled the Articles of the Barons. The Archbishop of Canterbury, Stephen Langton, acted as a mediator and drafted the Great Charter, or the Magna Carta, and both sides agreed to it on June 15th, 1215. Chapter 39 of the 1215 Magna Carta contains one of the most famous sections of the Charter. It reads, "No free man shall be taken or imprisoned or deceased," which means loses property, "or outlawed or exiled or in any way ruined, nor will we go against or send against him, except by the lawful judgment of his peers or by the law of his land." And this is generally what's pointed to as the inception of the concept of a jury. In the US Constitution, 1787, there are several references to a jury. In Article 3, it reads, "Trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where said crimes shall have been committed." So it was a right to trial by jury in criminal cases. The Fifth Amendment in 1791 in the Bill of Rights, "No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury." I'll mention more about a grand jury later, but a capital crime is a crime where you, if convicted, you could lose your life, your head. Sixth Amendment in 1791, Bill of Rights. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And then the Seventh Amendment, 1792, Bill of Rights. In suits at common law where the value and controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. And just to point out, and we'll talk more about this later, but the facts, what a jury does in the trial is actually determine facts, not law. So if there's a factual dispute as to who ran the red light, for example, that would be determined by the jury. And theoretically, once the jury has determined that it was party A that ran the red light, not party B, that fact is generally not re-examined by either the trial court or the Court of Appeals. It's presumed that the jury has made that finding of fact, and that finding of fact usually is preserved. Okay, these are some slides that I got from the Houston Bar Association. A jury is a fundamental American right. Having a representative jury of one's peers is fundamental to justice. The trial by jury is guaranteed in both the Texas constitutions and the United States constitutions, which we just looked. And most Americans feel that the jury system is fair and just. So what's the problem? The jury system takes care of itself, right? Here's some issues. Public perception. Why bother with jury duty? This is going to be boring. This is going to last a long time. This is a waste of time. I won't make a difference. And then there's other things that you may have thought about when you've been called down for jury duty. Most of the time, these preconceptions are often misconceptions. Most jury trials last actually about 2 or 3 days. All juries do make a difference. And it's actually different when you think about it in Harris County than it might be back in rural America years ago, because in rural America, maybe everybody on the jury knew everybody that was actually involved in the trial. That's very rare in Harris County that you go down to the courthouse and one of the jurors actually knows one of the attorneys. I've seen it happen, but it's awfully rare. And it also usually happens if one of the lawyers is one of the lawyers that's been in the media quite a bit, and then people know that person, if not because they're friends, but because they've seen them on television, and so on and so forth. But most of the time, jurors in Harris County don't know the parties in the case or the attorneys in the case, or often even the judge in the case. But those are the parties that the lawyers will argue to and try to convince the jurors that the facts support a finding of party A ran the red light or party B ran the red light. According to a 2000 study, jury service participation, adults between 18 and 24, 8% actually participated, but 37% could have participated had they actually gone down and showed up for jury service. Hispanic Americans, 9% actually showed up. 23% could have potentially shown up. Households earning less than $35,000 a year back in 2000, 14% actually showed up. 40% could have showed up. That, as we'll talk about when we get to jury selection, that can make a difference as well, because you're trying to get a cross section of the community, not just a particular slice of the community, to make decisions in these cases. 2000, at least 80% of those summoned in Dallas County disregarded the summons. Theoretically, there's a penalty, like a fine or something of that nature, that can be assessed against people that do not show up for jury duty. But very rarely is that exercised. So what ultimately happens is that these counties, where they realize that a lot of the people summoned will not show up, if they figure that they're going to need 3 or 4 jury panels on a particular given day, will just send out that many more summons so that they have enough jurors that they can fill the 3 or 4 jury trials that are starting that particular day. So actual jury participation was low compared to potential segment participation from many segments. Again, this is a 2005 study. Average jury turnout is 17%. 10 zip codes with the highest turnout in this study were 30%, were predominantly white. 10 zip codes with the lowest turnout, all below 10%, were predominantly Hispanic or Black. Again, that would have an impact, probably more in criminal cases than in civil cases, but it would still certainly have an impact. And the lowest jury participation occurred in predominantly Hispanic neighborhoods, as low as 5%. This is Houston Chronicle 2005. Let's see. This was an article in 2005 from the Houston Chronicle, which made the argument that turnout skews jury's makeup. And again, everybody that is a citizen has the right to serve on a jury, but whether they actually, when requested, actually serve on that jury, not everybody does, just like not everybody votes, but you theoretically have the right if you can get to a place to vote. Ultimately, low turnout reflects a failure to view jury duty as a priority and as a civic obligation. It's John D. Douglas, a professor at the University of Houston Law Center. And then this slide says, you have two direct opportunities to participate in your government. You can vote, and you can serve on a jury. So those are your opportunities, and hopefully you think of them as obligations. What did our country's founding fathers think? I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution. That was Thomas Jefferson. The right to trial by jury is the heart and lungs of liberty. That was John Adams. Why does it matter? Cross-section of all citizens is crucial for a jury of one peers. I'll stop here, and many of you have probably read or seen the movie or seen the play of To Kill a Mockingbird. And you'll know in that particular case, the defendant was a Black man. He was accused of raping a white woman, and the jury was all white men. And the Supreme Court of the United States has said that deselecting people because of their race was a violation of their constitutional rights. But back when To Kill a Mockingbird was done, the only people that could serve on jury were white men, and that is not a cross-section of all the citizens of any particular county, including that county in Alabama. It's your chance to do something about it by participating in jury, and it could be your case someday where you need a jury, and you hope that you get a good cross-section of citizens to hear your case and decide on your case. Americans have served their country to protect the liberties guaranteed by the Constitution. I know that one of the federal judges in the federal court, he oftentimes gives a fairly extensive opening to the jurors that are serving on the jury panel before they're actually selected for the actual petite jury that hears the case, before voir dire begins, which I'll talk about in a little bit. But this is a very patriotic duty that you have, and it almost feels like it's an obligation because you have liberties guaranteed by the Constitution. But when called upon, this is your chance to participate in the process, and hopefully justice in the case that you're trying will be done, because you'll be determining the facts. So to ensure that the government doesn't decide a person's fate, a la King Richard I, now the people do. They'll decide the person's fate in court, whether civil or criminal. Civil rights, an expansion of the right to serve. Before the civil rights movement in the 50s and 60s, juries in this country excluded minorities and women. I've given this presentation before, and I remember how many people, especially my age or older, that just seems shocking to them. And I guess it is shocking now. But back then, even though you would have all these citizens that could serve on jury, if they were minorities or women, they were actually excluded from the right to serve, but no longer. Power of the people, the role of the jury in the judicial system. We elect others to represent us as president, senators, representatives, and judges. Being a jury entitles each of us, regardless of wealth, background, or education, an equal voice and a direct role in the administration of justice. By serving, you have a direct impact in ensuring justice is obtained. Who's eligible to serve on a jury? To be eligible, potential jurors must be a citizen of the United States and of this state, 18 years of age, reside in the county of the jury service, be able to read and write in English, by the way, must know English, and be of sound mind. You cannot serve on a jury if you have been convicted of a felony or any type of theft. This is in Texas, unless your rights have been restored. If you are on probation or deferred adjudication for a felony or any type of theft, or you are under indictment for a felony or are under criminal charges for any type of theft. Challenges confronting a jury, there is exemptions, which means you're entitled not to serve if you want. If you're over 70 years of age, you have legal custody of a child under 10 years of age, and jury service would leave the child unsupervised, are a student in class, are the caretaker of a person who is unable to take care of themselves, can show a physical or mental impairment or an inability to comprehend or communicate in English. And that obviously is going to have an impact on the jury pool, but these are exemptions that are considered by the legislatures who enacted these exemptions as important, because you want to have people taking care of kids or invalids, or they're students and they need to go to class. Many landmark court rulings started with a jury verdict. Juries shape American society in terms of civil rights, criminal matters, consumer protection, and matters involving your family. The legal system works because of you. Jurors work hard at coming to a fair and just decision. Juries are effective, and jury service is rewarding. Believe it or not, I was actually called to serve on a jury one time in a misdemeanor criminal case here in Harris County. And I found, when I was trying cases, I found that jurors did, because they're together for long periods of time, did appear that they formed friendships and so on and so forth. And I did find that jury service was rewarding. It's completely different than actually trying a case, where you're constantly focused on what evidence is coming in. Do you need to make an objection, and what arguments are you going to make to the jury? But the jury service is completely different, because you don't get to ask questions. You don't get to make any objections. You sort of watch the proceedings, listen to the arguments, and then back in the jury room, you discuss, or at least we discussed, in a very civil manner, what we thought the facts of that particular case were. So I did find jury service very rewarding. I'm surprised I got selected. Never thought I would, because I was a lawyer, but I got to do it one time. So if you get a summons, please answer the summons. If you're an employer, you cannot penalize employees for performing their civic responsibility. And if you're elected to serve on a jury, you will take an oath to do your best to render a just and fair decision. So the jury summons that you get in the mail, I'm not sure if they look like this anymore. You fill it out, this form, a jury summons. You'll put on your name, address, what your job is, your spouse's name and what their job is. And not much more. They used to ask your religion, but that's either not on the form or it's optional at this point. So selecting a jury. Selecting a jury is done through a process which is called the Texas voir dire, but it's another French phrase meaning voir dire, to speak what you see or to speak the truth. It's a way for the jurors to select a fair and impartial jury. So under the justice system, jurors may be questioned by each of the lawyers before they decide to remove, the lawyers decide to remove a certain number of jurors from the jury panel. So the concept is this: in most civil cases, for example, you have a jury pool of usually 40 to 60, depending on the case, jurors, potential jurors. There's two kinds of juries. There's the grand jury, which is a jury we'll talk about later, which lasts usually for 6 months in Harris County, and they decide what cases an indictment should issue in criminal cases. And then there's petite juries, and a petite jury is the jury that sits for each and every actual case that is tried, whether it's a civil case or a criminal case. And that's the only case that they work on. And once their work is done on that case, they're dismissed, and that's the end of it. So in a civil case, you usually have 45 to 60 jurors called up for the case, and they're given numbers, and they sit in the courtroom 1 through 10, 11 through 20, et cetera, up to say 45 jurors. Each of the lawyers, assuming it's a two-person case or two-party case, each of the lawyers usually has 6 preemptory strikes and an unlimited number of strikes for cause. A strike for cause, and I may be jumping ahead here. Let me go back to the PowerPoint a second. So jury strikes, challenges for cause. If a potential juror says or expresses a bias against the attorney's case or one of the parties, that can be a strike for cause. In other words, if the juror says, I believe, I haven't heard any of the evidence whatsoever, but I believe John Doe is guilty, that can be a challenge for cause, because they've expressed a bias and unwillingness to listen to the evidence and try to make a fair and impartial determination based on that evidence. One of the lawyers can make a challenge for cause. He or she doesn't have to use one of the 6 preemptory strikes that they have. And the judge will strike the juror. And they can do it several ways. The person can usually comes up to the bench where the judge is, and the 2 lawyers are there. The lawyers ask questions, the judge may ask questions, and then the judge will say, you can go take a seat. And then that juror, not knowing what the result of the discussion is, goes back and sits down wherever they're sitting in the courtroom. Then the judge may say to the lawyers, I'm going to strike juror number 6 for cause. But that juror won't know until the actual selection of the jury is done. For example, potential jurors who have a close relative of one of the parties or one of the lawyers, or if he or she works for a company that's part of the lawsuit, that could be a potential challenge for cause, because they may have a bias. Preemptory challenges, each, in a 2-party case, each side would get 6 peremptory challenges. Peremptory challenges are, you can strike a juror for basically no reason whatsoever, or some reason whatsoever, but you can't use that preemptory challenge to discriminate on the basis of race or gender. You have to have some race neutral or gender neutral reason to strike a particular jury. Oftentimes when I'm doing voir dire, which is talking to the jury panel as a whole, I will, make notes on my pad as I'm talking to jurors. And sometimes when you're talking to, that many people, 45 people, there may be somebody that just is glaring at you for some reason. They don't like you for some reason. You don't know what it is, can't figure it out, but that could be a reason I just don't have a good feeling about that juror, because they were looking at me like they felt something was wrong, or they were looking at my client like they felt something was wrong. So you get one side gets 6 of those, one side gets the other 6. And now we've got 45 people out there in the jury pool. And the first 12 people in a district court case, the first 12 people who have not been deselected by one of the peremptory strikes or by one of the challenges for cause, those 12 persons that are called up and sit in the jury box will be the petite jury for that case. Everybody else in the jury pool is dismissed. And it's always done from the beginning, 1 through 45. So if you're called into a jury pool in a particular case, if there were no challenges for cause, the jury would never get past juror number 24. Because if one side took peremptory challenges 1 through 6 and the other side took peremptory challenges 7 through 12, then the jury would be whoever's number 13 through 24, and you never get past 24. If there's challenges for cause, then you get past 24, depending on how many challenges for cause. And that's why they usually have a jury pool of about 45. That way, at the end of all the strikes and peremptory challenges, you'll be able to get 12 people to come up and sit in the jury box for that case. Stereotypes that affect selection: racial, gender, age, class, religion. When I first started practicing law back in 1982, there were books that talked about if you're trying a case, generally it was criminal cases, but if you're trying a case, what kind of people do you want to serve on your jury if you're a prosecutor or if you're a defense counsel? And they would go through the religions and how the religions might react to these various things. They go through races and age, class, gender, all those sorts of things. I'm not sure if those books, I guess they're still out there in the world, but I'm not sure that I've seen anything like that since the early 80s, simply because it's not politically correct. I assume that lawyers would have their own feelings about stereotypes and who might be a jury, who might be a good juror in their case. But those sorts of things, if you're called to the mat, so to speak, if I were to use a peremptory challenge on a particular, on let's say a woman in the case, I could be called up to the judge and say, Judge, we think, Mr. Henderson is making this determination simply because she's a woman, and I would have to show a reason why I deselected that person that was not based on some sort of racial or gender stereotype. And that's, again, there was a Supreme Court case back, I'm going to say probably in the 80s, which basically said you have a right as a citizen to serve on a jury. And so if you have a right as a citizen to serve on a jury, I can't be deselected from serving on a jury because of my race, gender, class, or religion. So that's protected. I'm going to come up with a different reason. Now, so here's the case that I was talking about, 1986, Batson versus Kentucky. Batson was an African-American man. He was on trial charged with second-degree burglary and receipt of stolen goods. During the jury selection, the prosecutor used his peremptory challenges to strike the 4 African-Americans in the jury pool, resulting in a jury composed of all whites. Batson was convicted on both of the charges against him. Okay, and so this case goes all the way up to the United States Supreme Court. And at the United States Supreme Court level, the Supreme Court held in this case that you have the right to serve on a jury. And so you cannot select or deselect someone just merely based on, in this case, their race. And that's become known as a Batson challenge. which is what I was talking about before, which is if I deselect someone, the other side can raise a Batson challenge, which requires me to go up to the judge and convince the judge that I deselected a particular jury for a reason other than race or gender. Challenges confronting a jury. In criminal cases, a jury must decide whether the person charged is guilty or not guilty. The accused is presumed innocent and the state must prove guilt beyond a reasonable doubt. Juries must reach a unanimous verdict in criminal trials. All 12 jurors must agree. Civil cases usually result from disagreements or disputes between two or more parties. Jury must answer questions of disputed fact based on the testimony and evidence admitted by the judge. The answer to these questions are called the verdict. In a civil case, 10 out of 12 jurors must reach the same verdict before it's passed. Is that it? Okay, I guess that was the end of the PowerPoint. So the process of the jury is that after those 12 persons are selected on the petite jury for your particular case, then you have opening argument, which is where you discuss, usually for the first time, to that jury what your case is about, and then you go into the presentation of evidence. Most of the time, judges, at least I would say since the 90s, have discouraged or said you cannot talk about any specific facts of your case in the voir dire portion of the case. So in other words, if you're selected onto a jury panel, you'll probably go in, you'll be introduced to the parties, and you'll be introduced in broad stroke to what this case is about. This case is about a breach of contract between these two parties, but the actual specifics of the breach of contract and all that sort of stuff is left for opening argument. So you can talk to the jury generally about other things like, have you ever been involved in a breach of contract with someone else? How did it turn out? What do you feel about the justice system? What do you feel about being a juror in this particular case? Those sorts of things. Generally in voir dire, you're trying to get to some sort of an understanding of whether you think that juror would be someone who, after listening to the evidence, which you know what that evidence is going to be, you feel like after listening to that evidence, they could fairly and impartially render a decision that would be in your favor after they hear that evidence. But actually specifically asking them about the evidence usually does not happen in voir dire, and asking for commitments in voir dire, which used to be very common, is now discouraged. And what that means is that if you find that so-and-so, some party did some action that hurt this other person, could you award $5 million? And then you try to get all the jurors to raise their hand and commit to that proposition. Again, that used to be common. It's discouraged now. And again, it's going to be by a case-by-case basis, depending on who the judge in your court is, as to what they will allow or not allow oftentimes in voir dire. Because obviously, if you could, you're going to say, now, if you find that this happened on this breach of contract, will you find that there was a breach of contract, and get everybody to commit to the facts of your case in voir dire. You can't talk about the facts of the case in that sort of a detail, and you're generally not entitled to ask for commitments. So in any event, were there some questions in the chat section?
No, there weren't any questions in the chat. However, we'd like to open it up if anyone is interested in asking directly a question to Mr. Henderson. Please feel free to unmute yourself or raise your hand and we can call on you to do so. No, it doesn't seem as though we have any in there. Let me go back to. And see if there were any questions that were asked when people registered.
You know, one thing that I was really interested in, and it would just amaze me, is how many of our community partners and our community leaders don't realize how important it is for them to become a juror. A lot of people try to get out of it, but you're making decisions about your own specific community. And you're deciding factors specifically about your own community. I'm just surprised that not so many people of our community, not so many community leaders are interested in attending or being jury members when it's actually affecting your own community. Could you expand on that a little?
Yeah, I think that it's important to try to get a cross section of people from your community onto the jury, into the jury pool, so that everybody, the judge, the lawyers, and the participants in the jury pool can make a difference in any particular given case. Again, as you saw from some of those slides, there seems to be, or at least there was when they did those slides, there seems to be less participation from certain groups and certain socioeconomic income levels. And that may be for a variety of reasons. It may be that it's harder for somebody that's in construction or something like that can get off, or if they don't have a great command of English, you know, they can't convince their boss that, you know, hey, I've been called to jury duty, I'd like to go down to jury duty. No, you need to go out and do this, that, or the other thing. And so, you know, what you've had and what I've had in my experience is, I would say generally, I have, the juries that I've had have primarily been middle class or more. And so I don't see a lot of people that are probably economically disadvantaged in the jury pool.
How about the younger generation? A lot of our college students that are eligible to be in jury duty, how many of that generation is actually becoming active in jury duty?
In what I've seen, I would say most of my jurors are usually middle-aged or older. There are some younger people that get on jury pools, but at that point, you're going to get to, you know, the selection process that the lawyers go through. A lot of times, if you go to a continuing legal education seminar where they're talking about jury selection and so on and so forth, they'll talk about how to identify in voir dire leaders and followers. And what that means is that sometimes when you are having your conversation with the 45 potential jurors, you'll have somebody that looks like they're going to be someone who will be able to convince other people, once they've decided whatever they've decided, that they'll be able to convince other people of the righteousness of their belief. And very often that's not younger people, because the process is newer to them and maybe they've not had as much life experience or something like that. And so you feel like, well, if I can get a leader on that jury that I think is going to be in my camp, I can live with whoever else these potential followers are, because I think what's going to happen is that if I can convince that leader will then, you know, help get these other individuals on my side. In fact, I'm trying to think. You may have heard it's talked about a lot in continuing legal education classes about the vanishing jury trial. And what that is that when I started practicing law in the 80s, we didn't have mediations. we didn't have so many arbitrations. So you'd file your lawsuit, you do a little bit of discovery, interrogatories, request for production of documents, maybe you take a few depositions, and then boom, you were off to trial. So you tried a lot more cases. Then mediation came in, which is usually required in most civil cases now. Mediation came in the 90s. It was remarkably successful and still is. I think 75% of cases that go to mediation get settled in mediation.
Mhm.
So those cases don't end up going to trial. The point of the matter is that, back in the 80s and 90s, I had a lot more trials
Mhm.
than I've had in, say, the last 20 years. But in one case that I was thinking about, that maybe was 4 years ago or something like that, I remember we did have two younger people. I don't remember if they were students or not, but they were fairly young. And they, of course, grew up in the generation, which they talk about a lot at the continuing legal education seminars, which is, how different generations might view evidence. What do baby boomers think about stuff? What do Generation X people think about stuff? And my remembrance in that case is that you're not supposed to have your iPhone while you're sitting in the jury box. And the younger people, you could tell it was driving them nuts. They just wanted to look at that iPhone and see something. And so that's something that you have to plan for.
It's like, let's hurry up and get this over with. I got a text I need to do. I got to check my social media. Yeah.
They had to get the text in. But as a result of that, my feeling is that I don't think that they were paying quite as much attention
Mhm.
to the presentation of evidence as maybe some of the older people that were on the jury. And in none of the cases that I can recall having were the young people the ones who were ultimately selected as the jury foreperson, which is one of the first things the juries do when they go back into the room, is they select a foreperson. So, somebody to handle the deliberations and fill out the paperwork and so on and so forth. So that may be a particular issue.
I have a question. What do you do, or what can be done for folks that may be, financially disenfranchised, single parents or people that are active in their community that are interested in serving on juries? But if you're saying that, the average trial will last, 3-4 days or whatever, and they're asked now to take off work, and they can't afford to miss, 3-4 days of not being paid to serve on a jury. What do you say to that? Or what can be done in that regards?
And when I first started practicing until, I'm going to say maybe 5 years ago or so, jurors got paid $6 a day to show up for jury duty, and parking was usually $12 a day. So it was a net loss of $6 a day for these people to come down and spend their entire day doing,
on top of missing work.
Yeah.
And so that's a problem. I think they bumped it up in Harris County now to maybe $40-45 or something like that. It's still not enough to address the concerns that you raise. To address the concerns that you raise, I think would require the government to create some sort of a fund where they could actually pay people, what they would make if they were working while they're performing this civic function. A lot of mediators, in fact, probably one of the reasons mediations are so successful, a lot of mediators will say during the mediation, if you don't know what a mediation is in a nutshell, let's say there's two parties and they're having a dispute. They come in front of a mediator who's an independent, a neutral. They talk about their case, then they go into separate rooms, and the mediator goes from room to room to room, trying to get the parties to budge on their positions. And in a civil case, try to get one side to pay a little bit more money to make the case go away. And on the other side, try to get the other party to take a little less to get the case to go away. So if at some point at the end of the day, both sides say, well, I'll pay $100, and the other side says, well, I'll take $100, they've been successful in the mediation. But one of the things that the mediators say in these things is that, look, today in this mediation, you have the right to decide your case and see if it gets resolved. Otherwise, you run the risk of going down to the courthouse and having 12 people who don't know you, don't particularly care about you, don't particularly do anything. They're going to decide this case for you. So this is your chance if you want to make try to make a decision about your case, because you're right. If a lot of people go down there, but even if they go down there and serve on a jury, they may not be particularly excited about it. And so, but both sides run that risk. But like I said, the one time I served on a jury, it was actually a pretty good experience. And I've noticed when I've tried cases and see people on jury, it seems like everybody, finds a friend or two or three on the jury. They all go to lunch and they talk to each other. So by the end of 3 days, some connection is usually made between some of the jurors. So it's actually, it's not a painful experience at all. If you can afford to do it, as you mentioned, that's an issue.
How do people even be selected? Like, how are they randomly chosen to even receive a jury summons to come, get on jury duty? Because I've met some people over the years that say I've gotten the jury duty or got the jury summons, once, twice a year or something like that. And some people their entire life that have never been chosen for jury duty.
I've never had one, never received one.
Wow, that's kind of
I've received 2 in probably in the last 15 years.
Mhm.
My thinking is that if you have a driver's license in Harris County or a voting ID in Harris County, you are on the rolls to be selected. I've been called down to jury duty over 40 years now, probably 5 or 6 times. So what is that? Once every 7 or 8 years, I get called to go down there. My wife, that's about the same for her too, in Harris County. I've never been called to federal court, but federal court, we're in the Southern District of Texas. It has a much bigger geographical area from which it can pull jurors. It's not just Harris County, it's several counties around here that it pulls jurors from. And then you may also be called if you're in the city of Houston or one of the other cities in Harris County, you may be called to those municipal courts on occasion to do municipal cases, which are usually traffic ticket type cases. Actually, there's 16 justices of the peace courts in Harris County, Texas. They're spread through all throughout Harris County. And you have the right in a jury case, as you saw from one of the slides that I put up there, if you have a dispute over $20, you're entitled to a jury if you want one. Although when I talk to people and say, you should take your case to small claims court or justice of the peace court, I caution, because the whole point of justice of the peace court is that you can prosecute your case now up to $20,000 in an environment where there's no rules of civil procedure, there's no rules of evidence. So you file your case, you go down, you tell the judge what you want to tell the judge, you show the judge whatever documents you want, the other side does the same thing. But if you have a jury, then you've got to, cross some Ts and dot some Is, which in some cases defeats the purpose of a justice of the peace court case. Because normally, if you don't have a jury, you don't have those sorts of rules. But they can get them. I've heard stories. This is not personal knowledge, but I've heard stories where a justice of the peace court has, had to have a jury, and they just tell the sheriff to go to the HEB across the street, pick up 6 people and bring them back. So I don't know how they do it in justice of the peace court, but I'm surprised that you would have never been called to jury duty in Harris County.
I live in Galveston County, so I have not been called, or I have received, a request.
What happens if someone doesn't even acknowledge, they get their jury summons in the mail and they just disregard it? Now I'm like, I'm not going to this, and I'm not, and then they just decide, forget it. What happens?
There is a fine that they could face, but I don't think with any consistency that they prosecute those cases. And that's why it remains low, because the fear of any sort of retaliation it's just not there. And so what they do in lieu of that is that they just call bunches and bunches of people down to the courthouse so that they have enough to do the juries for that day. Now, to that point, they have, I'm going to say roughly 25 district court cases, criminal, and say 20 civil cases, district courts. And usually they know on any particular day, on this day, we are going to have a jury. So usually they know on the day that you're called to go down to jury duty, how many panels they have to have ready to go. So to that end, if they know that on this particular day, they're going to have 4 juries, and each jury is going to have 45 people in them. So then that's 90, that's 180. They've got to have 180. They've got to send out enough jury summons. So even if their return rate is 20%, they're going to have 180 people that they can send to the 4 courts for that particular day.
And it would usually, is that the county clerk that sends the jury request, or is it district clerk or county clerk, or is it different in different entities?
Is that a question again?
Oh, sorry about that. Is it the county clerk that sends out the jury duty request, or is it the county district clerk? Who sends those requests to the community to attend jury duty? Who picks them?
Well, let me see if there's something on this slide that'll tell me that.
I think it's a county clerk, because there was something a couple of years or maybe a year ago about Brazoria County Clerk picking personally who was, it might have not been Brazoria, but it was a county clerk that was specifically picking specific people, to attend jury duty.
See something here. So I showed this before. I'm screen sharing. You can see this is Gloria Hopkins, district clerk, and this is County of Fort Bend. My thinking is that both the district clerk would get the jurors for the district courts, and the county court would get the jurors for the county court. They may use the same jury area, but it would be the different clerks. Because when I've gone down there, I think every time that I've gone down there, Yeah, so when I've been down there, been called to voir dire panels in district courts and in county courts, because the case that I actually served on, which was a misdemeanor, was, I believe, a county court matter. And I know that sometimes when you go down there, whoever the district clerk is for Harris County or Galveston County will actually come in and greet the jurors and so on and so forth, and give them a speech similar to part of what I've talked about here. You know, this is a great chance for you to participate in our government and so on and so forth. And that's probably good for them, because as politicians of sorts, that gives them the opportunity to get in front of people and say, hey, you know, I'm the district clerk, and why don't you be happy that you've been called to jury service, and here's why you're doing a great thing, and so on and so forth. And maybe press the flesh a little bit so they can get reelected.
I'm big, and I'm sure I'm not the only one that loves Law and Order. So, you know, everybody that watches Law and Order are now pseudo attorneys, and, you know, we know everything about law. But what happens when you have those cases that where, I guess mostly in criminal cases, where somebody says that they don't feel like they would get a fair trial because, you know, they don't feel like they'd be tried fairly by a jury of their peers, and they move jurisdictions. How is it that how is that selection process then done? If you take a case that is not made up entirely of anybody of your geographical region to kind of make a decision about your particular criminal case?
Well, as a general proposition, a criminal case is tried in the county where the crime is committed. Okay, but in certain cases where there's a vast amount of pretrial publicity and so on and so forth, the lawyers, usually the defense lawyers, file a motion with the court to have the venue transferred to a different county, still in Texas, but a different county. And the reason being is that because of the vast pretrial publicity they've had in Harris County on this particular case, it will be unlikely that they'll be able to get a jury past all the strikes for cause that we talked about, because everybody will have an opinion. It says, has anybody heard about the case of John Doe? Yeah, we've all heard about it. Does anybody feel like they know whether John Doe is guilty or not? Yeah, he's guilty, he's sin, and so on and so forth. So you don't want that. So the defense lawyer would let him, will transfer us to, Lubbock County or something like that, where they're, nobody's heard about the John Doe case and so on and so forth. They're very few. And so you're going to get down to a jury that hasn't heard anything about the case, which is the kind of jury you generally want. Those motions are generally disfavored. So if you're the defense lawyer and you try to get it transferred into another county, yeah, you've got the uphill battle, but that would be the concept. Am I answering your question at all, or?
Yeah, that pretty much kind of summed it up.
Yeah.
And
You have to file a motion and get the judge to agree with you.
In child support cases now, and even divorce, they're going to arbitration first and not even to a judge. You have to go through a process of arbitration. And then after, I guess, so many arbitration meetings, then you go into, even to discuss your child support or your divorce with a judge, or, not even jury service. Of course, has nothing to do with jury service, but all of that is an arbitration also.
Okay. Well, thank you very much. Oh, I'm sorry. Go ahead.
Well, I was just going to say, judges are particularly enamored with mediations. And for the last 25 years, probably, they've been required in most civil cases that I've been involved with. And that's because 75% of them end up settling. which means the judge has one less case that he or she has to worry about at that particular point. So
Why do court cases take so long? I've seen people that have been on trial, well, not people, court cases that go on for like years and years and years before they, why does it actually take that long? That's a good question.
good question.
Figured that.
I don't watch much Law and Order, but my
Well, of
wife
course,
and I do
they're-
sometimes watch Perry Mason.
I used to love that.
I
Yeah.
did too.
Right,
And
Burr, yeah.
it's always great to see, Perry Mason, he gets his client, he sends Paul Drake out to do a little detective work, and then we're at trial. Listen,
Yeah,
man,
it's all done in an hour. Yeah.
How did that
I
happen?
don't understand.
Who knew?
yeah, well, in criminal cases, there's a provision in the Constitution which requires that you have a speedy trial. So that they have to, if you're charged with a crime, you have to get in to have your case tried within a certain period of time. But you can, if you want, waive that right. And so then the process can take a little bit longer if that's what the parties want to do. In civil cases, things can take an incredibly long period of time. One of the first reasons is because there's so many civil cases filed, and there's only a certain number of civil courts, and so that causes a backlog. The Supreme Court many years ago said you have to be up for your first trial date in a civil case within 18 months. So that sort of became the standard. So if you file a civil case, you usually get a docket control order, which says, here's all your deadlines, and you're going to have your first trial date within 18 months. But most judges allow parties at least one continuance. And if you're a defendant and you don't have any particular upside to going to trial, then you can file a motion for continuance and get it bumped. So now you're going into 2 years. In civil cases, you're entitled to do pretty much unlimited discovery. So you can take, interrogatories, requests for production of documents, requests for admissions, and then depositions of all these various assorted and sundry people. And, it keeps the lawyers busy, but it also doesn't lead to anything remotely resembling a fast trial. And then compound that beginning in March of 2020 with COVID. When that happened, they shut the courts down for about 6 months, and that pushed everything back. And I'm still seeing in cases where the courts are just continuing cases, not because the parties don't want to go to trial, but simply because what they do in civil cases is they say, okay, these are the 30 cases that we're going to try during this 2-week period. And then it comes up on that 2-week period, and the court starts going down the list of those 30 cases. Are you ready to go to trial? No, we want to continue. Are you ready to go to trial? And then you get 1, 2, maybe 3 cases to try during that 3-week period, and the rest of them, they get pushed off for another 3-4 months. And so COVID's been a big problem. It's been a big problem. During COVID, I tried one case. It was a bench trial, and it was by Zoom. And it actually worked okay, but it's a completely different dynamic than being down at the courthouse with everybody else. And that was a bench trial, so there were no jurors. They reconfigured the district court cases so that they could have jury trials. As you may recall, they used to pick the jurors out at NRG Stadium. And then after the 12 were selected for the petite jury out at NRG Stadium, then they all met the next day in the actual courtroom. But to have social distancing and those sorts of things in those courtrooms, they would have the judge where the judge usually sits. If you know what these courtrooms look like, basic courtroom, judge sits on the bench. The witness sat in the jury box. That's way over here. The lawyers would sit at their tables, spread apart, and the jurors would sit in what is generally referred to as the peanut gallery, which is in a court. They always have the swinging doors, and that's called the bar. And so the lawyers and the witness and the judge are in front of the bar, and everybody that's just watching the case is behind the bar in this area that they refer to as the peanut gallery. But they've put the jurors out there in that peanut gallery area so that they can all have social distance. And then they've got all the screens, which used to be in the jury box, 12 by 15 little TV screens. Those were projected onto big screens so that all the jurors, all spread apart in the back, could see, because a lot of times in civil cases, you're looking at pictures or you're looking at documents and language, and you want everybody to be able to look at the same passage at the same time. And so that's how they would do that, so that the jurors could all see those things while they were socially distanced in the back of the courtroom. But again, they just couldn't try that many cases. So that's backed up the system a little bit.
Okay.
And then to finish that answer, in both civil cases and criminal cases, you have the right to an appeal. And that takes you to a different court. And that court usually takes a long time too. I think I had an appeal that was just dismissed, but it took a year to get to that point. And it wasn't even heard, and it wasn't even decided on the merits. It was just dismissed after a year. So that process can take a long time. And unless the Court of Appeals can do several things, it can affirm the case, which means everything was done right. Whatever happened in the district court, that's the decision in the case. Or they can reverse and potentially send it back to the same trial court to try the case all over again. So say if you have one of those cases that's gone on for 10 some years, you probably had some appeals in the middle of it for some reason, which would delay the whole process even further.
Well, thank you so much. We've really enjoyed it. This has been informational, interesting, and I've learned so much. How about you, Nia?
I got my little notebook here, and I'm writing my stuff down. So yeah, it's been very interesting. So thank you very much, Mr. Henderson. On behalf of A Month of Service and all of our partners, we certainly appreciate you taking the time out your day to provide this information to the community. And in addition to that, to all of our participants who have joined us today on Facebook, as well as here on Zoom, thank you guys for joining us this afternoon. That's all we have for today. Later this week, what do we have coming up? On tomorrow, we have our monthly first-time homebuyer education class, and ask that you guys join us again on Thursday at 1 p.m. for how to handle inherited property, including title concerns and title and probate concerns. So if you guys are having any kind of heirship problems with inherited property that you guys have received or what have you, then please feel free to join us for that. There's a lot of information that's going to be covered from there. Let's see what we have next week coming up. HOAs in Texas, that's been a hot button issue that a lot of folks have been asking us about. So we're providing you with information about HOAs in Texas, as well as property taxes, with deadlines and things like that have passed. And we're now moving into February. I'm pretty sure those tax bills have now incurred, penalties and things like that for folks that have not paid their property taxes. If they have questions or concerns about that, that will be definitely a great one to sign up for. And then evictions next Thursday, and knowing what your rights are. Since the moratorium is over, lots of folks don't know what the next step is or what the process is. So definitely feel free to tune in and join us for that. So again, Mr. Henderson, thank you very much.
Good job.
We hope that you all have a wonderful afternoon, and just remind you to continue to stay safe, protect yourself, and have a safe and wonderful day.
Bye, everyone.
Thank
Have a
you,
great
bye.
day.
Thank you.
Thank you, Mr. Henderson. Great job.